So, boundaries of the corporate form was the first substantive topic that we did, and I'm going to now I'll talk you through the slides for the purposes of revision. So the first thing, if you remember, we spoke about was the question of what companies are for, what their purpose is, and company law began in the form of a concession system where the government would make available the corporate form on an ad hoc basis for projects deemed deserving of the corporate form. That ends in 1844, and companies can be incorporated by anyone for the purposes they choose, but there was a requirement for a certain number of incorporators, originally 25, later 7. And that then led to the famous Salomon case, which you will have read by now. And the effect of that case was that the important dictum of it is that as long as you follow the procedures when a company is set up, that is a validly incorporated company. So in particular, it's not necessary that of those 7 members that were required at the time, any of them had to be more than a human being who agreed to become the holder of one share. That's all that was required. So there was no substantive requirement for them to operate as true partners. So Salomon and Salomon moves company law from its original purpose, which was to facilitate large-scale projects, into a small and medium-sized enterprise space where companies can be used as they are now frequently for the purposes of small businesses such as the business of the leather merchant Mr. Salomon. And that makes perfect sense. Company law should be there to support small businesses. But the question is, are there limits to it? And the question is in particular, so I gave you the example of shipping companies. In international shipping, every ship is held by an independent company, or rather by a company that forms part of a group of companies, so that when something goes wrong, you can just say, okay, well, that was an accident. Ship is on the ground of the ocean. Too bad. The company doesn't have any assets, so there's no liability for that accident. Now, so we're approaching the question: should there be limits? And a good case illustrating the problem is Adams and Cape. I'm sure you remember this was about a miner in a South African mining company, and the question became one of, is a successful, so that the miner himself and his co-claimants were successful in obtaining a judgment against the parent company in the United States, and the court in Texas concluded that the UK parent is liable to pay for damage suffered by a miner in South Africa who was employed by the South African mining company. That tells you that in the United States, the corporate veil isn't as robust as in the UK, because the UK court said the fact that that US judgment wasn't enforceable in the UK. And that was because the UK parent wasn't present in the litigation. So I say that Adams and Cape is a good case for exploring the limits. That's because it concerned a miner, a vulnerable employee of a South African subsidiary of a profitable international corporation. So the question is, what's the problem? Well, the problem is there are adjusting creditors. So those are banks who lend, we don't feel particularly sorry for them because they can protect themselves through a contract. And there are non-adjusting creditors like the miner in South Africa, but also like a tort victim of a shipping accident, and those can't protect themselves. In the case of the miner, that's because they don't have the bargaining power necessary to insist on certain employment terms. So then we kind of can conclude there are some creditors for whom it is very difficult to manage this risk created by limited liability. There is a point, though, that's a point on asset partitioning, and that says limited liability also benefits creditors. So from the perspective of the South African miner, Mr. Adams, his position is that his claim is against the South African subsidiary. And in relation to that subsidiary, he has priority as a creditor over creditors of other members within the group. So, for example, he does not have to be worried about a lender of the American subsidiary to claim for the mine as a valuable asset of the South African subsidiary, or some American consumers who successfully sue the American subsidiary cannot enforce that claim against the South African mining company. So the idea is sometimes creditors benefit from a robust approach. It's important to say sometimes because the chances are that subsidiaries in countries with vulnerable employees are very likely to have fairly limited resources. Okay, so I've set up the problem. The question is, what are the limits, and are we setting the right limits? Let's talk about limits. The first and very obvious limit is fraud, and the leading case is Standard Chartered Bank. That was a case where both the company and its director and shareholder were personally liable for a fraud they had committed. They had backdated shipping documents, and the court said, well, the fact that this was done by a director and when he was acting as a director doesn't mean they're personally liable. So that's if a shareholder or a director is implicated in a fraud, they will be themselves personally liable, even if they channel the fraud through a company. Then negligence can also lead to liability. That's not tortious liability. Williams and Natural Life Health Foods was a case where there was no liability because Mr. Mistlin in that case hadn't assumed responsibility. So you remember that this was the health food shop case where the Williamses were receiving negligent advice about the suitability of their business plan. Here is a case where there was a successful claim, and that was Mr. Chandler against Cape, and that was the case of this shared factory facility which had an open side, so it had just 3 walls, and asbestos dust migrated. And the parent company had assumed overall responsibility for the management of the site. Subsidiary was relying on the parent company's work for the management of health and safety. And so the result was the parent company was liable because, and that's really important, it owed its own duty of care. It was a direct duty of care under the rules under the tort of negligence. Here's an example where no claim happened. This was the Unilever case, which concerned a tea plantation in Kenya, and there were outbreaks of violence following an election, and some mobs outside the plantation harmed the residents of the plantation, And the question was, is the parent company liable? The answer was no, it's not, because it wasn't sufficiently involved in the risk management of the subsidiary. That was left with the subsidiary. Here's an example. That was the Newton-Seeley case, had to do with a security worker securing a site in a war zone, and there they were exposed directly to the parent companies, giving them inadequate equipment and instructions. So we can see that there's a sort of overall line to be drawn between how much is the parent company involved in micromanaging the subsidiary. The more they involve themselves in the risk management of the subsidiary, the more likely they are to be negligent, or rather to be liable under the tort of negligent. And then Brumder and Motornet is a little appendix to all of this, because that was a director who was responsible for the health and safety of a workshop, of a car repair shop, and he injured himself, and the answer was, well, hang on, you were the director, you're responsible for health and safety in this office or in this workshop, and you cannot turn around and say, I'm suing the company for my own negligence. So the tort of negligence is a mechanism through which we can manage the problems of limited liability, but there's only liability of a parent to a tort victim of the subsidiary if the parent has involved itself in the activity of the subsidiary. So it's a fair level of micromanagement that you need to prove to succeed. Okay, so then veil piercing as a separate doctrine, or maybe veil piercing is just something that is just a label for other doctrines as we apply them in company law. And the source of the questions here are the terms sham or mere facade, and they were articulated in Adams and Cape and in other cases which I'll come to. But since Petrodel impressed, that heading is still exists, and I'm sure it will resurface in due course in the cases. But Petrodel impressed has concluded that's not quite the right way of analyzing what's happening. Now let's look at Petrodel impressed. Petrodel impressed was a case involving a divorce, involving matrimonial property, and the husband controlled some companies, and they owned properties in London. And the question was, are those properties part of the matrimonial estate and subject to dividing them up in the divorce proceedings? And for that to be the case, the wife had to show that the husband was entitled to the properties. And the family court said, yes, he was, because of veil piercing. He was sort of an owner of those properties, and therefore these assets form part of the matrimonial estate. And this then went all the way up to the Supreme Court, and the assumption speech is sort of one of the speeches that are worth reading here. And he says, actually, the term veil piercing isn't useful. That describes too much. For example, it describes fraud, which is just fraud. So we don't need to call it veil piercing. So the idea of a mere facade or a sham is also not great, because the courts don't do some justice exercise. They do more than just say this is fair or this is unfair. You also observe that in all previous cases, most statements were made obiter, and most cases actually should have been decided on other grounds. So he says what came before him was confused. Sometimes things were called veil piercing when they should have had another label, and and that kind of misled us into thinking that the courts will be generous in the interests of justice, and also there were just many statements made obiter. Okay, so let's look at pre-Prest. Sham and facade then. Here are the two cases. Guilford, Motor and Horn was the case about an anti-competition clause, and Jones and Lippmann were cases on sale of land which was sold, and then the vendor felt sorry for having done that, and so he sold it onwards to a company he controlled, but the court still gave an order for specific performance so that the original buyer would get the land. And that was because the company was a device and a sham, a mask, which Mr. Lippmann held before his face. So we can see in both cases the language of sham and facade or cloak were used. Now, how do we analyze this? These two cases actually could have been decided on other grounds. So you could have said in Jones and Lippmann that the company was a constructive trustee, and so for example, and that was therefore, you could say they weren't really veil-piercing cases, but Sumption says we still have to take them at their face value, but the terms sham and facade are not helpful. The most helpful term is a better term is evasion. So he says these two cases are cases where the corporate form, the company, was used to deliberately avoid an existing obligation. Then he goes on to say, and the other cases, or some other cases in this area, can be explained on the grounds of concealment. So that would be a situation where, like Gencor and Dalby, where the company was used to hide profits that the director had been hiding from another company, and actually the company was just a constructive trustee, like if it was Dalby's uncle. Trustor and Smallbone is a similar situation. So Sumption then says evasion is veil-piercing, and he also says, I just know two cases. Everything else, concealment, is a better label for the application of equitable principles. Now, then you get Neuberger, and he says the doctrine isn't helpful. We should really actually forget about it, but unfortunately it's accepted by all common law jurisdictions, and so it's a potentially valuable tool, and there we are, better keep it. And that's also what Mance and Clark say. There's a sort of, but there's an understanding that exceptions are not easy to establish. And Walker says it's not a doctrine. It has nothing to do. There's nothing special. It's just a label for other doctrines. So one question that is sort of brewing on in this area is this veil-piercing something special, or is it just an application of equitable principles? And I think Prest is authority for the fact it's probably a label, but there is a possibility that there is something particular about it, and the judges did not want to close the door on it. So there it is. Veil piercing exists. Then for the distinction of evasion and concealment, that's a difficult distinction to make, and I note that not all the members of the Supreme Court endorse that sort of distinction. So that's kind of course, Sumption's a big point, and of course it's a Supreme Court decision and a very eminent judge, but there's that, so there'll be, because it's also not easy to make as a distinction, we'll probably see some movement on that. And then here are examples of how this deliberate evasion of existing obligation has been usefully employed or used in the context of criminal law. So we are sort of concluding on Petro dell'Imprest, I think the conclusion we need to make is it's veil piercing continues to be a doctrine to a very limited extent. There's this addition case, sort of Rosendale, which I also gave you, and that also stresses how limited that doctrine is. Another question is, does sham and facade still exist? And the answer is not quite clear because, of course, in Petro dell'Imprest, the decision was obiter. So that what you read about veil piercing was an obiter because the case was decided on other grounds, and I'll come to those. Those grounds were trust law, because the Supreme Court concluded that these companies, whatever they were and whoever controlled them, on the facts they could conclude, they felt that the companies were holding the London properties on trust for the husband. And so everything was easy because you could use his beneficial interest and divide that up in the divorce. So actually it was an example of concealment. But of course, and far as evasion and concealment and that distinction is concerned, that is an obiter from the perspective of applying it in the future. So it's quite possible that sham and facade will pop up again. And there's another example, Clegg and Patch, also of a situation where the company holds an asset on trust for someone and therefore has to account. Okay, so we've spoken about trust law as a mechanism through which sometimes a director or a company is liable as a constructive trustee. And then, of course, there are some statutes. And the two cases we looked at were the film case and the Daimler case. Film case had to do with a film that was made basically in the US by mostly Americans, but through the vehicle of a UK registered company. But that wasn't enough to qualify for the film to qualify for tax relief that was available at the time. The Daimler case was set against the background of the First World War. And the question was, is the Daimler company, that means the UK registered Daimler company, an enemy under the Trading with the Enemy Act? And the answer was yes, it is. It's not enough for the company to be just registered here. There were too many connecting factors with residents, with German residents. Okay, other example is the senior accounting officers of large companies have a personal liability for tax. And the Scottish Energy case, which was the case of trading restrictions for certain deprived areas, and the parent company was liable because it was a trader. Okay, so statute then, DHN Food and Wolfson and Strathclyde were also statutory cases where there was a question of a compensation claim for expropriation. The claim was successful in DHN Food, but wasn't successful in Wolfson. And those are hard to distinguish as cases. But all those cases are cases where you need to apply some statutory rules, and sometimes a parent company is caught by the rules as an actor in its own right. Okay, and then sometimes a parent company can be an agent for a subsidiary. This was mentioned in Adams and Cape, although there it didn't happen. There was no agency relationship, but in a case called Schlegel or Orta, Kliege and Schlegel, there was one representative, and on the facts he represented all the members of a group. So it is possible if you find that the same person represents the parent and the subsidiary company, both are liable because on the facts, this person is an agent for both. Now, then the wrongful trading rules are rules where sometimes a parent company can be liable or a shareholder can be liable because they're a shadow director. And wrongful trading, well, you will have studied now in the context of directors' duties. So here, it's just enough to say that a shadow director can be a shareholder, and then we can establish shareholder liability. So the Company Directors Disqualification Act, which you now will also have studied in the second term, has also allows an intervention, a disqualification of someone who has been has shown himself unfit to be concerned with the management of a company, and there's disqualification both for directors and shadow directors. So overall then, are we setting the right limits? So all these tools we have looked at lead us to the conclusion that the principle of veil piercing is very weak, or rather the veil is rarely pierced, and there's rarely liability of a shareholder or a director, and therefore the corporate veil is quite robust. And the question for you to think about is that something that you agree with, or is that something you would like to criticize? Are you worried about Mr. Adams? Are you concerned about shipping companies? Should there be circumstances in which a parent company is liable, or also the residents of that Kenyan plantation?